number 116954 in the matter of J.O.
May it please the court, justices and Chief Justice. This case has to do with a purchase of marijuana wax and marijuana from a minor that was set up by the city of Prairie Village, and the actual purchase occurred in the city of Shawnee, Kansas, which is 10 miles away from Prairie Village. The issues that we are raising are very connected to this court's previous ruling in State versus Brable. In the particular case that is before the court, my client was an underage person. Prairie Village Police Department decided they wanted to basically start setting up drug buys. So they contacted Shawnee. Shawnee had a confidential informant. So Prairie Village started talking to him and decided that they would be able to then set up buys.
Is that accurate? Doesn't the record reflect that Shawnee contacted Prairie Village and asked them to work with this confidential informant because they didn't have the manpower to do so?
What Shawnee had actually done was said that they are no longer working confidential informants, and if Prairie Village would like to that they were welcome to speak to people within the city of Shawnee. They didn't indicate that they were transferring their police authority to the city of Prairie Village to set up drug buys in their community. They simply said, we have a confidential informant. If you guys would like to see if he can help you, then they were open to then here's his name, and Prairie Village then started speaking with this individual.
Who contacted whom? Who contacted whom initially?
It was my understanding it was a mutual communication. I understood that Prairie Village was speaking with the city of Shawnee. It may have been that the city of Shawnee indicated they were terminating their confidential employment.
The record doesn't tell us who contacted whom the
Correct.
first time.
That they were no longer pursuing their confidential informant program. At that point in time, as it started, Prairie Village contacted this individual and asked him to go find people that he could buy drugs from. They spoke with him in the city of Prairie Village. They set up, when he found someone that he could find for them to go buy drugs from, he contacted the Prairie Village Police Department and said, hey, I can go buy drugs from this person in the city of Shawnee. And Prairie Village then gathered the money, gathered the recording devices, and set up the drug buy with the confidential informant in the city of Shawnee. The city of Shawnee is 10 miles from Prairie Village. It's not even adjoining. It is 10 miles away from the city of Prairie Village. Upon setting up the first drug buy in August, they gave the city about 45 minutes before the purchase was to occur. They called the city of Shawnee and said, hey, we have a drug buy set up. Do you guys want to do it? And the city of Shawnee said, we don't have the manpower. Go ahead and handle it. Obviously, this was not the city of Shawnee contacting the city of Prairie Village saying, we want you to come handle drug buys. Prairie Village contacted Shawnee.
Counsel, the thing that keeps bugging me about this case is I can't figure out what the defendant's interest is in making sure that the Prairie Village Police stays within its municipal boundaries. This seems to be a fight, that there should be a fight between Prairie Village and the city of Shawnee, and doesn't really involve you. So what's your interest in this municipal boundary legislation?
Our interest is that we believe that when there are laws that police officers are required to follow and they blatantly violate those laws, that they should not be rewarded by being able to then have young people criminally charged because of their willful and recurrent violations of the law.
Seems like you're arguing for the right to be able to commit a crime in a location where it's not, where the laws aren't being enforced because of a lack of manpower.
And that's not at all what I'm asking for, because honestly, this whole ordeal was orchestrated by Prairie Village. It was orchestrated by the Prairie Village Police Department. There wasn't anything that indicated to the city of Shawnee if
Your
Prairie
client
Village,
sold drugs to somebody. That's against the law. Now,
I'm-
if you have an entrapment defense, go have fun with that. That's fine. But your client committed a crime, and it seems like the only thing you're saying here is that we should be allowed to commit the crime because there was a violation of this statute that says the Prairie Village Police needs to stay within its municipal boundaries.
and that is not, I'm not saying anybody should be allowed to commit a crime. I would never suggest that anybody should be allowed to commit a crime. But I also don't believe that where law enforcement is committing crimes in these actions.
Is it a
that-
crime for the Prairie Village Police to enforce laws over in Shawnee?
the
It
district
violates
court,
a statute, but it's not a criminal statute, is it?
the district court found that the Prairie Village Police Department were violating the law because they were
But it
acting
wasn't a crime. I mean,
outside.
it's a law. It's a civil law about municipal jurisdictions. It's not a crime. You can't say that they've committed a crime.
This court in Vrabel did say where the law enforcement is acting outside of their jurisdiction and outside of their authority, that they are committing a crime, and that is what the district court found. Because if you're not acting within your law enforcement authority when you're setting up a drug deal and financing a drug deal, then you are committing a crime. They're not acting under their law enforcement authority.
Didn't Judge Foster even go so far as to say that when these officers testified, he would advise them to about their Fifth Amendment rights?
He did.
But since we're at that point, why isn't that a sufficient deterrent? Why is suppression an additional deterring remedy that you can ask for? Why isn't one deterrent remedy, which Judge Foster put in place in this case, sufficient?
Partially because of prosecutorial discretion. So in this case, the state had already provided that these officers would be immune from being prosecuted. And so the court saying that he would advise them of their Fifth Amendment right, the state and Johnson County would have to choose to charge them for this, and they have the discretion whether or not to choose to charge them. They don't have to charge everything, as we all know. And so they would have to choose to charge them for violating this law, which they were not doing. In fact, they had been informed of their opportunities for immunity. So,
And the charge would have been aiding and abetting in the commission of this crime.
correct, at a minimum. And in fact, they were the ones that they are the ones that funded it. They were the ones that sought the purchase of these illegal drugs. And therefore, I don't believe that I do believe it is a law violation for someone who is acting outside of any legal police authority to go and set up a drug buy and then to just say, well, it was just, I was doing it because I left my city doesn't mean that it's not the right thing to do. And to me, one of the biggest issues is that the Vrabel case had to do with the Prairie Village Police Department. And the Prairie Village Police Department then, after Vrabel is issued, where you have said willful and recurrent violations of this could implement the exclusionary rule, they then continue to do it 2 more times in August and in September, and therefore the district court found that it was a willful violation. Now the district court found that it was bound by Vrabel, which made total sense to me, that the Supreme Court had made it very clear that you guys are the ones that are to determine when the exclusionary rule in this situation should apply.
Let me ask you about that, because it struck me that you're familiar with the Robinson case that discussed Vrabel after it had come out. And I think Robinson speaks pretty clearly about the language in Vrabel. There wasn't a holding in Vrabel that said a willful. I mean, it was mildly seductive that there might be this argument out there. So that's all we said. Robinson comes along after that, and I think pretty forcefully discredits that. The district court in your case comes in and says it's duty bound to follow the law of the Kansas Supreme Court and only references Vrabel but doesn't reference Robinson, which strikes me as odd since it came out, it was a more recent case. How do you square the analysis in Robinson and that's outcome and have it be consistent with what you're asking us to do here? You see what I'm asking?
I do. I believe that it's a difference in the facts. Robinson wasn't the Prairie Village Police Department. Robinson wasn't people that were immediately doing exactly what they had just been told not to do. And I believe that I understand that the exclusionary rule is a strong and very forceful tool. However, I believe that in the facts of this case are different, and that this case is so directly connected to Vrabel in light of the fact that it's the exact same behavior by the exact same police department, that I think you can see it consistently in that it's neither. It allows this court to still support Vrabel. I mean, it wasn't overturned. It wasn't held as for naught. However, I think that the facts in this particular case allow this court to do what's right. And in many aspects, as I had spoken about prosecutorial discretion, I think it sends a message to the district attorneys that we can only take so much. You know, you have to abide by some level of law.
Is that the heart of your argument, kind of, we can only take so much? Or, and I guess that would be premised on an acceptance by you of the holdings in Vrabel and Robinson that this statute does not vest an individual right. Are you challenging that fundamental holding or not?
I'm not challenging that fundamental holding. I understand that fundamental holding.
So then all you really are left with is kind of, we can only take so much of this kind of.
Right. At what point in time are the police allowed to violate the law and it's going to be tolerated by the Supreme
Aren't there
Court?
other remedies available aside from suppression? I mean, we've talked a little bit about some of the remedies, the cautions that were put in place by the district court, but aren't there also potentially civil remedies available?
Well, the only way that a civil remedy would be, I mean, you could sue them, however, it still doesn't overturn the criminal conviction, and it doesn't upset the criminal conviction, and it doesn't necessarily deter them from the criminal conviction, because in suing them, you would have to then be able to show that their actions weren't justified and weren't accepted, however they were, because the court, because my client was convicted. So I'm sorry, I did forget to tell you, I was going to reserve 4 minutes. I would like to reserve 3 minutes. Is it too late?
No, 3 minutes is granted.
Okay, thank you.
May it please the court, I'm Andrew Jennings and I represent the appellee, the state of Kansas in this case. The state's requesting that this court affirm the Court of Appeals order that correctly ruled that the application of the exclusionary rule in this case was not appropriate, which is consistent with this court's holding in the Vrabel case, in the Robinson case, as was alluded to, as well as other cases that this court has come through.
Counsel?
Yes.
Can we talk about what remedies might be available if the exclusionary rule is inappropriate here?
Absolutely, Your Honor. This court had hinted at, Judge Foster did decide that the Prairie Village police officers had potentially committed a criminal act, did advise them that he would warn them of their Fifth Amendment rights, although they had already testified about what had taken place, and that's certainly a deterrent. I think that the court also has the ability, or the legislature has the ability, to draft potential remedies to this if they thought it was an epidemic of a problem, much like the statute that governs traffic stops for racial profiling says unlawful seizures as opposed to unconstitutional seizures.
Well, can the Prairie Village Police Department just ignore what we said in Vrabel? That appears to be what happened here. They're just ignoring our caveat, our warnings, and just continuing as they did in Vrabel.
I don't
That's
think,
what Judge Foster found. That this was not it was unilaterally organized by the Prairie Village Police Department. It couldn't be characterized as a request for assistance. All the things that we talked about in Vrabel were just repeated here and repeated before this too. What do we do?
Your Honor, I think
What
that,
do they do?
what does Prairie Village do?
Yeah, or what happens here when we have this just ignoring the we don't do this very often and say these are actions we can take. This is unusual, and now we have not only resistance but just no attention being paid to that. What do we do?
And I guess I disagree that Prairie Village has been totally disregarding that, but I would agree with you that the police department.
That's pretty much how Judge Foster saw it anyway. Looking how he characterized it. But go ahead. What do we do?
Absolutely, Your Honor. I think that as the Court of Appeals characterized in this case, there was, this was a 4-count complaint initially. It had charged for an August of 2015 buy, and it had charged for a September of 2015 buy. When they examined the purpose of the exclusionary rule, they said the one buy that was arguably still in violation of that statute had been dismissed, and that any deterrence or any remedy of dismissing the September buy would be minimal compared with that. So I think although the appeal of this case is, hey, it was Prairie Village and Vrabel, we're back here again, it's Prairie Village again, I'd urge this court not to lose sight of the forest for the trees and still examine the individual facts of this case.
I'm a little confused by that, counsel.
Certainly.
So you're saying they mitigated their behavior by dismissing the counts that arose out of the earlier buy. That's what you're saying, in essence? That cost them something, that they had to dismiss that count.
Certainly.
Is that what you're saying?
That's what the Court of Appeals said, Your Honor,
Okay.
in relation to that.
So it was okay a month later? I mean, I don't get that. It was okay a month later to do it? I mean, they weren't any less well-informed at that point about what we had said in Vrabel, were they?
I would guess I would disagree and agree with the Court of Appeals assessment of that, although that Judge Foster did find that there were willful and recurrent violations of this law. This court said that that may trigger the application of the exclusionary rule.
Right.
And if we look at that September buy and look at the facts of that, would that merit the application of the exclusionary rule? And I think the Court of Appeals had disagreed with Judge Foster's characterization that this was a willful and recurrent violation for the one buy, because there was just that one adjudication in this case for that one count of that.
But the facts are there were 2 back-to-back in August and September.
That's correct, Your Honor.
There's a pattern. I mean, it's not like they're really, just because only one of them ended up getting prosecuted to conclusion doesn't mean the other one didn't happen, does it? Because we're talking about the behavior leading to the charges, excuse me, the behavior leading to the charges, not whether he ended up convicted of them. I mean, it's kind of like a cake and eat it too situation here. The prosecution can't say, oh, well, you know, there's no individual right that arises out of this statute limiting jurisdiction of these police departments, so you can't apply the exclusionary rule. At the same time, it says, we dismiss the case, so what's the harm? I mean, to me, it's a little bit disingenuous.
Certainly, Your Honor, and the state certainly appreciates that. The state would try and distinguish that from going back in time if the state never had charged that August 2015 act. For the respondent then at the district court level to try and bring up, well, Prairie Village has done this on prior occasions. I think the state would certainly have a good faith argument that that's not a case or controversy in front of this court. It's just the one adjudication. So I certainly understand after the fact, we can't pretend that that August buy didn't happen because it did.
Yeah, I don't think the fact that it was dismissed ultimately is very persuasive for that reason, because it's part of the pattern.
Was the August buy dismissed because the prosecutor told the Prairie Village Police Department, I need to teach you a lesson, I've read Vrabel?
No.
What was the reason given then?
It was just, I believe, it was due to just a stipulation of facts for purposes of that trial. This state had, and this isn't, I'll preface this with, this is not in the record. Both counsel and I were trial counsel, and I can tell the court, we had approached the respondent with pleading to one count out of each buy to preserve those for the record. I think how the state would characterize it now is any remedy that this court wants to entertain, let's teach Prairie Village a lesson, let's reverse this adjudication and send that message. That's already been dismissed, but I can tell the court it was not dismissed with my admonition to the Prairie Village Police Department. You violated the law, and I'm gonna punish you as a prosecutor for that. If that makes sense.
It makes some sense, but I think what Justice Beyer was getting at, as I understood it, was that act still occurred with the Prairie Village Police Department's participation.
Absolutely.
Correct? Okay.
Let me pursue something that's bothering me about the district court order. And I'm premising this on the notion that a court's let's just assume that language in Vrabel that, you know, this is mildly seductive, that's telling district courts that they have discretion to suppress if there's willful misconduct or willful violations of these statutes. So that's my premise. Did Judge Foster misunderstand the law, if that's the premise, when he said, I have no choice but to permit this case to go forward, this count to go forward? I mean, he didn't suppress the evidence, and he seemed to say he was duty-bound to follow the law of the Kansas Supreme Court, and then he cites Vrabel for all of that, which of course doesn't make sense to me. But did he misunderstand the law? Did he have discretion and misunderstood the law, thinking he didn't have discretion?
I think that Judge Foster's interpretation of that was, if it is for a court to, just as that pay heed kind of cautionary tale at the end of Vrabel may trigger application of the exclusionary rule, that he read that to say it is not upon a district court or a court of appeals to take that first leap. Otherwise, I believe he would have. He read that to say, in Vrabel, when this court talked about the concurring opinion at the court of appeals level in Vrabel, that said it's not the court of appeals job to disagree with this court, to make its own rationale. And I think Judge Foster, if he would have thought he had discretion to suppress the entire thing, would have done so.
He just didn't think we had given him that discretion yet.
Yes.
And that's not I see that, okay.
Can we get back to my question? What do we do? You said that perhaps an admonishment or that the law enforcement officers about to testify could be given their Fifth Amendment rights, that perhaps they committed a crime. What else can happen here besides that?
In the state's ideal world, hopefully this court would decide this was improvidently granted and say, we'll leave it for another day to do so. I certainly understand that's not likely in this case. I think that outside of the Fifth Amendment, I think this court could certainly, and has done so before in the context of juvenile law cases, said, for example, in the probable cause, we encourage the legislature to create a procedure that would help rectify the confusion district courts are faced with in regards to probable cause hearings. I think this court could certainly say it would be the legislature's place to provide a remedy, and we'd encourage them to do so, but it's a legislative decision that would do so, because again, we're not dealing with a constitutional right here, but a violation of the statute.
Why, as the Hawaii court said, and the Colorado court, I think as well, that we cited in Vrabel, recognize that the court has inherent authority to make sure that the justice system runs appropriately. Why would you say we don't have that authority? Why would we look to the legislature to establish that statute?
And I apologize if I misspoke. I certainly think this court has the authority to do so. I think the state's position would be we would urge you not to use that authority in this specific case. So I think the court...
And why not? Why isn't this supposed, if that authority exists, let's just assume that as a baseline. If that authority exists, why isn't this a poster child for its exercise?
I think when the court looks at the individual adjudication that's before the court that happened that August and looks at the transcript of what Prairie Village did, the Court of Appeals, I believe, said it was in nominal compliance with that statute. And I think that to look for in the exclusionary rule, I think if we just said academically, Prairie Village willfully and recurrently violated the statute, yes or no on do we create a rule, I think you can't do that without looking at the facts of the case. And I think,
what's the nominal compliance here? What is the nominal compliance with the statute here? There was a request from Shawnee?
Yes, Your Honor. That there was both, and I think one of the opening
That there was both what?
There was both a macro level request and a micro level request. I think one of the court's first questions from my opposing counsel was, where did this confidential informant come from? And if you look at the record, Detective Mahoney and Sergeant Gray from Prairie Village both say they had contacted us, can you take over?
Those are all factual questions.
Absolutely.
And we have a district court that made a factual determination that that there were willful and recurrent violations by PVPD. Did we not?
Absolutely.
So we have a district court making a factual finding. Have you appealed that finding?
There was not a cross appeal.
And if the Court of Appeals wants to reweigh that or reweigh the evidence or reassess credibility, that's improper, isn't it? So why aren't we dealing with what we said in Grable is this court cannot sanction willful and recurrent violations of the law, end quote. Judge Foster says PVPD is willfully and recurrently violating the law. So why are we talking about all the rest of the facts, who talked to whom first and all of that? Because we have the fact finder making that specific finding.
Your Honor, I direct your attention to it's an unpublished Court of Appeals case that the state cited before the Court of Appeals, and the Court of Appeals cited as well, where the state had not cross-appealed a finding that a search warrant, that the good faith exception didn't save the search warrant. The Court of Appeals said, we need to look at those underlying facts, although the state did not file a cross-appeal, because any application of, in this case, the exclusionary rule, would require us to look at those facts. And so I think that this court would have to look at those facts, and I think that's what the Court of Appeals here did. There can be a willful and recurrent violation, but should it trigger the exclusionary rule?
Well, that's the legal question.
Absolutely.
Should it? But I understood we were arguing about whether it was a willful and recurrent violation.
I would agree with Your Honor that I think the state is stuck in the position that the district court made a factual finding there was a willful and recurrent violation of law.
I'd like to return to where we were a few minutes ago in your response to some of my colleagues' questions. You seem to give away a lot really quickly by conceding that we had virtually unbound inherent authority to fashion a remedy. Some of our case law suggests that's not the case. For example, the Sherman case, we said our inherent authority does not extend so far as to reverse a conviction as a sanction for prosecutorial misconduct. Were we wrong when we said that?
No, and I apologize if I misspoke. Both the Sherman case and the
Robinson
case
as well talks about this.
Contextualize that, and I think in both cases it's hinted that the judiciary does have some inherent authority, but it's not being utilized in this case, and I think goes back and ties in well with Vrabel. While it may be seductive to look at that, I believe the Kansas Association of Criminal Defense Lawyers had submitted an amicus brief in that case, citing some of those cases, but I don't think it has ever been employed by this court, and I would agree. There's two
separate questions. One is, does the inherent authority of the court extend that far? That's one question. And then if the answer to that is yes, then you get sort of into the world of discretion. Well, given the facts of this case, should we choose to exercise that authority? But I don't think we should blur those two questions.
I would agree with that, Your Honor.
Okay.
And Vrabel didn't cut that inherent power from whole cloth. It relied upon a Hawaii case and a Colorado case, and so it wasn't just divined in that case. There are others that have said that their court can't sanction illegality and can't adulterate their court proceedings with unlawfully obtained evidence. So, I mean, there's case law out there to support that proposition, although it's still open to debate in this state, I suppose. But you would agree that there is case law out there to support that inherent power.
From those other jurisdictions,
Yeah,
like
right.
Your Honor said.
Counsel, having heard all the questions and your answers, can you tell us what you want the court to do now?
Yes, we would like this court to affirm the Court of Appeals affirmation of the trial court's ruling in this case.
All right. Any further questions? Thank you, counsel.
Thank you.
In response to the state, I have just a couple of things to clarify. One, the Court of Appeals in their decision indicated that the Shawnee officer stated he couldn't remember if he was at the scene or listened in, whereas the actual testimony that is included in our petition for review is that the officer from Shawnee was nowhere in the vicinity and did not listen in and had no involvement in this investigation. What I believe is part of the problem is that if the legislature wanted Prairie Village to become the DEA of Kansas or even of Johnson County, they could provide legislature that would allow them to go wherever they wanted to go to do whatever they wanted to do. That is not what our laws have provided for, and I don't believe that this is appropriate. And as it relates to the dismissal of the August claim, it was simply a negotiation to streamline the trial to stipulated facts so that we could get to this point, because both the state and I knew that we would be appealing this to the courts of appeals in order to get more resolution, because partially based on Judge Foster's finding that he felt that Vrabel kind of tied his hands, and that with that he believed that this is the court that is to determine when enough is enough as opposed to a district court.
How do you rectify your argument with Sherman and Robinson? Did our holdings in those cases basically take away any right you have to argue for suppression in this case?
I don't believe so. I believe that this court has, especially in Vrabel and other cases, acknowledged that you have broad discretion as it relates to the exclusionary rule. And I say broad, some discretion. I mean, obviously it's not something that's just going to widely be granted for anything that happens. In this particular case, I believe that those are consistent, that being able to apply that exclusionary rule is consistent based on the facts of this case. And the facts of this case include the exact same actors as acted in the previous case, and acted multiple times in this case, the same as they acted in the previous case. And I believe when you look at the specific facts of our case, it allows you the discretion to do what needs to be done to send the actual message, which has never been sent to Prairie Village or never received by Prairie Village. I think there was a message sent, but I don't believe it was received, that these actions were inappropriate and illegal and should not be occurring.
Any further presentation?
Thank you, and we do ask that the court set aside suppress the evidence and set aside the decision on the motion to suppress in this particular action.
Okay. Do we have any questions?
Let me ask you about that real quick. Can we do that? It seems to me that, it gets back to my question to the state. It seems to me that if there's a mistake at all, it's that Judge Foster didn't think he had discretion to take the next step to consider whether to suppress, as opposed to suppressing. So if we decide that district courts have that legal authority, don't we have to send it back to him and say, okay, you were wrong when you said you don't have, you were duty bound. So now what do you want to do?
If this is how that court chooses to do it, to remand it, to set aside his finding that he was duty bound and find that to be inappropriate and remand it, it's clear that Judge Foster found that this was a recurrent and willful violation of the laws of the state of Kansas. So I believe that
That wouldn't necessarily mandate the result, though, that you're
correct. It wouldn't mandate him
and
changing.
So then he can consider other things like this deal where Shawnee passed off this guy, and can consider all that stuff as to whether it mitigates the notion of suppression.
And he did consider all of that in his opinion. He considered
But not in this context.
But not from the standpoint of what he considered all of that, and then ultimately said these were all willful recurrent violations, which was warned of in Vrabel, and then the Supreme Court said we're not going to tolerate this. But my interpretation of that is that the Supreme Court is the ones that draw that line based on those findings, and he felt that that's who had to make that decision. If this court decides to send that back to allow him to make that decision, then I understand that. Although we would prefer this court just go ahead and grant the previous request.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time